See, where you watch?
They didn't tell you there was a road trip.
You there?
They would do.
Okay.
They told me they didn't want me to stop. They were meeting in the office.
Okay.
So I got the
We're moving the mic here. Okay. All right. Is that on? Okay. Little mic. Yeah. Okay. Please rise. Dear Heavenly Father, we pray that you bless us in this meeting and keep us. Lord, make your face shine upon us with your grace. We pray that we feel your presence during this meeting because you are with us wherever we go. We pray that this meeting focuses upon your plan you have for us. Let our actions in this meeting be valuable to our aim, which is to build up and help one another. Amen.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Morning. Commissioner Musara is not with us in person today. He's with us by phone. He's home sick, so he's on our speakerphone. So he will be here for the meeting and can hear us via telephone. This time convene the Commissioners meeting and have approval of the minutes of the previous meeting.
I'll move to approve.
I'll second.
All in favor say aye.
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 So carried. This time we'll have public comment on agenda items only. Mr. Lauer, come to the microphone up front, please. Identify your name and your address, please, for the record.
Todd Lauer, Jersey Shore, Porter Township. I want to comment on action item 8.5, agreement with Steel Fusion Clinical Toxicology. Now, I'm probably wrong on this because usually Ms. Toon's right, but I asked her the other day if there was an increase. She said no. So whether the increase was between 2018 and 2019, I don't know. But the paperwork I have from 2018 says approved professional service agreement with Steel Fusion for $300 a case. Now, maybe it went up in 2019, I don't know. I wasn't attending that many meetings last year. I was on the trail, but, and I'd like to also comment, we have all these agreements with these toxicological places. Here we have agreement with Siemens for drug screen systems. We have the pre-release center with O'Leary Toxicological Services, you know, farm chemicals. We have all these toxicological services. I just am curious, is there any way we can put this all into one service so we don't have to have all these people feeding off our tax dollars? Thank you.
Thank you.
So is the question whether or not one company could do it, Mr. Lauer, or is the...
Yes.
I think the problem is that some companies provide some services and some provide others. But when someone comes into the custody of the county, we need to know, we have a legal responsibility to know whether or not they are on a controlled substance or some other
Illegal substance.
illegal substance, yeah. But, Maya,
Yes,
on the question of the cost, did it go up or?
the cost, it varies because each time you're adding a different drug.
Different
So
panels.
to say that the majority of the major process did not go up. But if they have to add different things because the fentanyl and a different drug that comes on board for
Yeah.
toxicology services, then it does go up.
I'll give you a good example. About 2 years ago, we weren't testing in the adult probation for synthetic marijuana,
K2.
K2. And we found that people were coming in and it was not in the screen. It wasn't, It wasn't being screened because it wasn't in the panel of drugs they tested for. We then started testing for K2 because more people were using it in the, illegally in the community. And so we needed to know.
And you can have a 3-panel, you can have a 4 or 5. A lot of times we do a 9-panel. It just depends what's requested and required.
So there is an increase, correct?
Yeah, it
From
could,
300 to 350, that is an increase.
It's 325.
well, it's an increase in the sense that we're buying a different service. But I think what Ms. Toon was telling us is they're not charging us more for the same services we purchased before. If I go into the supermarket and I buy tomatoes, it's the same price for the tomatoes. If I add cucumbers, I'm paying more. So, but thanks for paying attention to that.
Thank you.
Thank you. Any other public comment on the agenda items only? Okay.
Okay, so we're going to move to 4.0 personnel actions with Roxanne Greco. Approve the following personnel actions.
Roxanne?
Good morning, Commissioners. In the District Attorney's Office, we have Karen L. Wilson as a full-time replacement clerk 3, pay grade 4, $13.95 an hour, effective January 27th, 2020. Also in the District Attorney's Office, Marcella A. DeSano as a full-time replacement clerk 3, pay grade 4, $13.95 an hour, effective January 27th, 2020.
Okay, any discussion on the personnel actions? Have a motion to accept them?
I'll move to approve the personnel actions read by the director.
And I'll second that.
All in favor, say aye.
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 So carried, thank you.
Thank you.
Yes, convene the Commissioners meeting at this time and go to public hearing for the county zoning ordinance amendment.
Good morning, Commissioners. I'm here to present an amendment to the Lycoming County zoning ordinance to allow hunting preserves as a use within the countryside, resource protection, and agricultural zoning districts by special exception with appropriate supplemental controls. Over the summer, a landowner approached us from Muncie Township interested in erecting a fence around his property in order to operate a hunting preserve on his property. It quickly became apparent that we currently did not provide for the use in the ordinance and that an amendment to the ordinance would be needed to rectify the situation. We discussed the use with the township, and later on in August, we discussed the use with the Lycoming County Planning Commission, who decided to form an ad hoc committee to discuss the use and appropriate supplemental controls. We also contacted representatives with the Pennsylvania Game Commission and Pennsylvania Department of Agriculture to determine how they regulate these uses. After the ad hoc committee met, an ordinance amendment or ordinance language was drafted, and we took the proposed amendment to a public meeting on October 4th or on October 24th in the Trade and Transit Center, designed to get feedback from municipalities within the county zoning partnership to gauge their feelings on the proposed amendment. After the discussion, minor changes to the ordinance were made. The ordinance amendment was presented at the November 21st County Planning Commission meeting, and the Planning Commission voted to recommend approval of the ordinance amendment by the Lycoming County Commissioners. The amendment was sent to the partner municipalities for review and comment, as is required by the ordinance. All municipalities who responded indicated that they had no comments on the proposed ordinance amendment. The amendment was advertised as required on January 9th and January 16th. Through the amendment process, some concerns about potential impacts to neighborhoods surrounding any proposed hunting preserves were raised. However, it was determined that those issues could be addressed in the special exception process and that the zoning hearing board could attach reasonable conditions to mitigate potential issues, or they could deny the use if they determined that the use was not compatible with the neighborhood. The amendment defines the use to include fenced operations intended to hold domestically raised game intended for commercial hunting and trapping. However, the use also includes operations regulated by the Pennsylvania Game Commission as regulated hunting grounds, which provide commercial hunting for certain game bird species. Applicants will need to have 100 contiguous acres for the operation, which is undivided by public or private right-of-ways intended for the conveyance of automobiles. Applicants will need to provide a fence around the operation, and the fence will need to extend 2 feet underground or be electrified 2 feet above ground in order to prevent boar and other animals from burrowing under the fence. Regulated hunting grounds do not need to provide a fence, but do need to mark the boundary of the property as is required by the Pennsylvania Game Commission. And that's because those are specifically designed for hunting game birds, and they don't need a fence. Enclosures will need to be erected at least 450 feet from neighboring residents, any neighboring agricultural building used to house livestock, a school, a daycare facility, or playground associated with the school. Commercial hunting operations can only operate from sunrise to sunset. The owner will need to provide any required federal, state, local permits needed for the use. The use will be allowed a structure for lodging of guests and for conducting business, a butcher structure for the hunting preserve customers may also be allowed as an accessory to the hunting preserve use. The general site plan will also be required for special exception applications for this use. This time, I'll take any kind of questions.
So I just want to, for the public, want to clarify. This ordinance applies to the 26 entities, municipalities that are covered by county zoning.
It's actually 21.
21, thank you. And of the 21, as the solicitor just informed me, it only applies if in the 21 they have either countryside, resource protection, or agriculture. So it's a very limited, and do you happen to know off the top of your head which of the 21 have countryside, resource protection, and agriculture?
I've actually looked at it before, and all municipalities in the ordinance have one of those 3 zoning districts.
Okay, all of the 21?
Yes.
Okay, so it has to have one of the 3, right,
Yeah.
right. All of them have at least one of the 3.
Yes,
All right, that
exactly.
makes sense, because most of them are outside of the municipal area.
Most of them are very rural.
Very rural, right.
Yes.
So just so the public understands, it's not county-wide. It has to be, first, it has to be that they're covered by the county zoning, that they have voluntarily voted, the leadership of that municipality voted to be it. And then it has to have either countryside, resource protection, or agriculture, which you tell us all of them have at least one.
And
Okay.
we operate this ordinance on behalf of the municipalities in the partnership, and after we sent it out to them, we gave them at least 2 opportunities to comment on it, and no one responded with any comments.
Right. And to the credit of the planning department, had we not taken the initiative to do this, anybody could just set one up anywhere in the 21, because it wouldn't be covered by our zoning ordinance, and therefore, you would have the right to do it, right?
There'd be an argument that
There'd
they
be-
would take steps to cure that issue.
Right.
Yeah.
But to avoid that, we're taking the proactive approach of putting it into the ordinance. Okay, I just wanted to clarify that.
Any other questions? We move on to public comment now.
Any public comment?
Just some handouts.
Thank you for being here. Thank you.
Thanks a lot. Yeah, we'll give to Commissioner Messer when he
And
comes
then
back.
you have one also, so it's in the record.
Yeah.
Thank you.
There you go. Thank you.
Thank you.
Okay, good morning, Commissioners. My name's John Dewald, address is 433 Market Street, Williamsport. I'm an attorney at McNerney Page, here today on behalf of William and Sue Keller. Mr. Keller sitting here in the audience, who Mr. Keller owns property in the Countryside District, and the landowner in question, I believe, is a neighboring property owner. So we don't dispute anything that was discussed with the process and the incentive to get this done. What I wanted to speak to is some additional supplemental controls which we believe are appropriate. So in the materials you have, there should be 4 exhibits. I will skip exhibit 3 and 4 are just the letters that we had previously sent to the Planning Commission and also to the Muncie Township supervisors. Exhibit 1 is the existing amendment as proposed. And you'll see on page 2, we would like to see some changes to that, which we have highlighted in yellow. The first of which is item D on that exhibit 1, which speaks to the unique nature of countryside districts. So definitionally, in your zoning ordinance, a countryside district is, quote, to permit residential development in, quote, a transitional district between nature and non-nature. So just definitionally, when you interject a hunting preserve, it seems adverse, and thus supplemental controls would be required. And I understand that that will be played out throughout the process, but the one thing that I believe is important to be codified by ordinance in D is a suggestion that the zoning hearing board officer would be looking to specific questions regarding topography of the property, and then also the means by which lethal dispensation will be provided. So if you look to exhibit 2, you can see the subject property in question, and I have 2 red dots on that map, one of which would be the edge of the field of the proposed hunting preserve, the other of which would be by my client's house. It's less than 600 feet, and it looks out over the entire village of Pennsdale. So when you look at a situation like that, it seems to me that additional requirements should be looked at. For instance, if this was just going to be an archery preserve, my client would have no concerns whatsoever. So we're just saying that the zoning hearing board officer should be looking at those considerations. And I believe the rest of the requested changes are all pretty much straightforward. So with that, I'll reserve time for any questions or comments that you might have.
Well, just,
Hey, this is Commissioner Mister.
Yes, no.
Tom, didn't you say that there were shooting lanes in that preserve that must be followed?
We discussed the possibility of requiring that in certain zoning districts, and we determined that most of these instances would come down to a case-by-case basis, and we'd look at specific special exception applications and determine if there was a need for those types of things, such as shooting lanes, to be identified as part of the special exception process.
And if you go to a special exception process, does that cost money?
Yes, it does.
Okay, and so why can't you clarify that within the ordinance now?
Well,
Instead of,
they would need to apply for a special exception either way. This would allow flexibility in areas where maybe that didn't make sense as much. For example, not all parts of the countryside zoning district are made equal. Some parts are more developed than others. In some areas, it might make sense to have a hunting preserve where there weren't required shooting lanes and similar requirements. And we felt that adversely, there might be situations in resource protection or agricultural zoning districts where they might be appropriate. So we felt that it would be more appropriate to address that issue during the special exception phase to provide more flexibility to the applicant.
thank you.
Yep.
so, on the special exception, the person moving for the preserve would be the person filing for the special exception. What burden would it be in this case? What burden or what protection would there be for the homeowner? Mr. Keller? So if this came up under the current situation, what would be Mr. Keller's obligation to do to protect his right to not have, I think what, Counsel, what you're saying is that you're concerned that a bullet might be a stray bullet and hit someone on his property.
Either damage property, persons.
Or damage a person.
Correct.
So I guess the question to either one is what is going to action have to be taken by the neighbor to protect themselves, and should we require that, or should people's ability to live without that danger, where they may have been living there for 30 years without having that, and move there with an expectation that it wasn't going to happen? That's my question.
Just real quick, I think Commissioner Maravito, what we have proposed there in Section D, I don't think is adverse in any way to what is being discussed. I mean, I think everyone wants to see safety of the landowners and property. In our opinion, this just specifically says, in the zoning districts where residential development is provided for, definitionally, that additional precautions will be taken in specific guidance for the zoning hearing board officer. So I don't think there's anything materially adverse which would be disrupted by this amendment by inclusion of that.
And alternatively, if there was a neighboring property owner that felt like they would be endangered by a proposed hunting preserve, then we notify surrounding neighbors, correct?
That's correct.
Whenever we get a special exception application. So at that point in time, that would trigger them being able to come to the zoning hearing board meeting and express any concerns they had, and then the zoning hearing board would take that into consideration.
One of the attributes, or one of the things I like about this is that I don't want the burden to be put on a person who may get some notice and not understand it, or may have to go out and hire counsel. I'd rather the burden be on the regulating authority to make sure that whoever wants to put the preserve in takes the steps necessary. The way it's written now without this, the person who is the going to be subject to it has to take the initiative, has to understand that they have a notice from the zoning board, has to actually take action. And I think in fairness to people who have moved into a district that they thought was not going to have this use, that the burden should be on the party seeking to it. It doesn't mean it's going to be denied. It just simply means that as part of the responsibility, they're going to make sure that the regulatory authority is going to make sure that they take care of that. Is that the crux of the problem?
Commissioner, I think the thing to remember is that the zoning hearing board has to do their due diligence during the process. So even if a landowner does not come forward and raise issues, the zoning hearing board will raise safety issues based upon the site plan and based upon what is being proposed for the preserve. So the zoning hearing board, it is their responsibility also to take all those safety considerations into the process of giving a permit or not giving a permit. So it's just an additional notice than when those zoning hearing boards, when they have a hearing about an actual application, it's also, they're notifying the surrounding landowners, because if there is a concern, they can come in and voice it, but the zoning hearing board should also be looking at those issues. So it's just an additional idea. And some of the things that were, all of the highlighted items that have been proposed here will be taken into consideration. For instance, the first one in D, the topography and everything is a safety concern, so that would be taken into consideration, and that would be part of the site plan. Also, under H, we really can't, it's a business that's being proposed, so how do we say whether or not somebody has experience? It would be like somebody's opening a McDonald's. Do we make sure they have a safe serve or something like that? That's the state's requirement, that they should be with their permitting. We can't require somebody have a business degree to open up a business. So it would be very difficult to do that. Also with I, Disposal of animals, that is also covered by the State Department of Ag. That's not something that we require. They already have regulations in place that any animals have to be disposed of properly by their regulations. We can't supersede that.
And they check that when they're inspecting these hunting preserves.
And under J, we actually already have that requirement in another part of the ordinance for any type of use. So, and we have discussed these at the planning commission, just so you're aware.
If it's okay, Commissioner,
Absolutely.
may I just, first off, I mean, this is what the public hearing process is supposed to do. And so the fact that Mr. Dewald is here with his clients presenting comment for your consideration is exactly what the process is supposed to do. And it's appreciated because it doesn't always happen often, and it's a nice presentation. Just a couple observations for your consideration. And I don't think that this was intentional on any part. I think it's just a function of the fact that there was a change in the ordinance, as was referenced by Tom, following the Planning Commission meeting, when in fact these same concerns were raised by letter at that time. If you look at the version of the ordinance that you have in front of you versus the version of the ordinance that Mr. Dewald has provided, there's a section that C that says it says enclosures for commercial hunting shall be erected at least 450 feet from the neighboring residence. That's the ordinance that's before you. The prior version, and a change that was made by the Planning Commission to reflect some of these comments at that level, was to change it from no enclosure from commercial hunting shall be erected within 450 feet to that at least 450 feet. And the thought and the comment that occurred at the Planning Commission was that that then gives the zoning hearing board some discretion to say, no, the standard is at least 450 feet, and it could be more depending upon the specifics of the application. And so one of the considerations that was made when these comments were raised at the Planning Commission was to make that amendment, because there was merit to the comment that there could be specifics of an application that would require more of a setback than just within 450 feet. You could have a need for more than 450 feet. And that comment was appreciated. Mr. Dewald raised it for his clients at that point, and the Planning Commission and the Planning Department considered that and made that change in the ordinance, which I think is intended, and the Planning Department can speak to this, but was intended to address the concern about the specifics of a particular area. So you really have two parts here. Your first part is the enactment of the ordinance. The second part is how the ordinance applies to a particular application. And those two things are distinct. And so what they're trying to do, as I understand it, and they can speak to it more themselves if need be, is to make sure that the general ordinance covers all the areas that they feel need to be covered, but then there's the flexibility when the application is presented to the zoning hearing board for the factors to come into play. And so the exhibit that Mr. Dewald has attached in terms of the specifics of the topography and the proximity of the proposed site shouldn't be something that comes into play for the general ordinance language, but certainly is very relevant at the time that they consider the particular application. And I think the Planning Department was, by making that change with the input from the Planning Commission, trying to give the board even more latitude to address the particulars of the topography. So, I mean, that comment was appreciated and that change was made to address it. Whether they feel that it needs more, whether you feel ultimately it needs something different, nevertheless, the comment was heard at the Planning Commission level, and the ordinance had that change, which is not insignificant in terms of the discretion it gives the board when an application comes forward, if that helps.
That does, thank you.
Mr. Dewald, with your permission, may I ask to hear from your client?
Sure.
I'd like to hear from your client in terms of what his concerns are.
Can I just make two replies briefly before I turn the floor over to Mr. Keller? One, I think first the analogy to McDonald's is very different here. We have a situation where a business would be entirely based around high-powered rifles, shotguns. I mean, that in and of itself requires additional supplemental controls, especially when you interject it's a countryside district which is intended, quote, to permit residential use. And I think, just to reply back to Solicitor Wiley, what we're saying in D, or what we're in 3D there in yellow, is I don't think in any way from all the comments not or materially adverse to what's being discussed. And specifically, we do understand that would be part of the special exception process. That's why we've noted that the zoning hearing board officer shall ensure not only the topography, but what the intended use of the hunters would be. Again, if this was something like an archery preserve, when you see on Exhibit 2, there would be no concerns for my client whatsoever. So it's all of those facts specifically. So with that, Mr. Keller.
And I said, here do I gotta get up there?
That's because the microphone's up there, sir.
Okay.
Thank you. Thank you for being here.
Okay. Well, I don't really know what to say other than myself and the neighbors are upset about it. We had a petition put out, which there were 58 names on it the very first week, concerned about the safety, the noise, and everything that goes with this. Nobody has even mentioned what this will do to land values in our area. I mean, this is, as far as all the neighbors around that I spoke with, this is not to enhance the neighborhood whatsoever. It is a detriment. I mean, high-powered rifles can travel 3 miles easily. That covers all of Pennsdale, even out to the new veterinarian center. If you sit up there and look, or if you even look at the area, especially since the vegetation is down, you can really see where this is. And I've lived there since 1974 and built my property. It's not a checkbook property, and now I'm retired, hope to enjoy my place. Am I gonna hear high-powered rifles going off all day long? And fear of being hit and bullet holes in my house. And that's what a lot of the other neighbors are. Safety is one of the big things. Like John mentioned, if they did go to archery, it would solve a lot of problems as far as noise, as far as safety, as long as all the other provisions was taken care of. The disposal of waste, the erosion, some of these places, the erosion, overpopulation of the animals, the erosion is just terrible. These have a place. I don't feel where the one that's being proposed is a place for this. For the neighborhood, the community, or anything else. That's my concern.
Questions? Mr. Massar, you have any questions? Mr. Keller?
Yeah, I got a couple.
Okay.
So, if when this was being proposed in the countryside, okay, Tom, this is for our employee Tom. Must we allow a hunting preserve in any one of our 21 municipal partnerships?
Yes, we must allow for the use of hunting preserves in the zoning ordinance.
But it doesn't necessarily have to be in the countryside, Tom.
Correct.
It just has to be somewhere in the zoning district.
Right, okay, and now,
provided within one of the zoning districts.
now that we have allowed one in one of our municipal partnerships, if another one wanted to pop up into, let's just say, on somewhere else, would we be able to refuse that because we already allowed one in one of our municipal partnerships?
Sorry, what? Can you rephrase that again?
If I may.
All right, let me rephrase it. If another preserve wanted to come in to town in one of our 21 partnerships, would we have the right to refuse it more easily because we already have one in it?
If I may, Commissioner Mike Wiley, I think I can answer that question for you legally.
Okay?
Each application has to be considered on its own merit. And so the fact that you deny under this ordinance or approve under this ordinance a particular application isn't relevant to a future application. So
Okay.
Presently, there is not a hunting preserve that's been approved under this ordinance. This ordinance is attempting to address that the fact that there's no language in the ordinance to address this use. But if your question is, hey, if we approve one, does that create a precedent? The answer would be no. Each one needs to be considered on its own merit against the ordinance on its own accord, given its location and the supplemental control factors and other factors under the ordinance, if that helps.
Mr. Massar, Mr. Wiley, we can approve the ordinance for resource protection and agriculture, correct?
Yeah, this is a legislative decision.
Right. It's a legislative decision, so we can approve it for the resource protection and agriculture and not approve it for countryside. If someone came along in the future and wanted to do it as resource protection in one and agriculture in another, what Mr. Wiley's saying is they could apply to do it in each one. Each one has to be on its own merit.
It's on its own.
But they wouldn't necessarily be able to apply in the countryside.
Yeah, I think if it helps, Commissioner, there is a distinction here. And the distinction is, where do you want to permit these theoretically within the county zoning ordinance function? And how a particular application then would be reviewed under the ordinance as approved. And so I think the decision that you're facing is, where do you permit it generally, and what controls do you put on it generally? And then the specifics of a particular application would be considered under the legislations passed. So however you pass this is then what would apply to any application.
So my question to our planning department is, when the issue came up with the planning commission as to whether or not to allow it in the countryside, what was the response of the planning commission?
There was some persons on the countryside, on the planning commission, this is Shannon Rossman, Commissioner Massar, just for your information.
Yeah.
For the planning commission, there was some concern in the countryside district for the allowance. However, it is more site specific, because that would be in the case of each individual application. There are a number of areas in the countryside where this will be appropriate, as hunting is probably already occurring in many of these areas already. The key thing to remember too, though, is we do not have an application. We have not adopted the ordinance yet. We do not have an application. We don't know what kind of considerations will be put on the application. We don't have an application to say exactly what this person is interested in. The reason this whole process has occurred is because he approached the county to see if he could do this on his property. And that was when we realized we did not allow for this use. There are a number of these grandfathered in across the county from one end to the other of the county. However, they have been in place for a very long time. And so that's why this process started. We do not have an application at this time. We do not know what is going to be proposed on this property. We just know that he would like to do this type of situation, type of use on his property.
Shannon, how many are, I'm sorry,
Okay.
how many are grandfathered in right now that you're aware of?
Aware of? I'd say we know of at least 3 that I can think of off the top of my head.
Possibly
Are
five.
they being regulated at all?
They're non-conforming under the ordinance, so if they were to expand, then at that point, they would need to get approval for that.
Are they
But
strictly archery, or are they arsenal, high power, rifle? All?
yeah, I'm pretty sure they're all, they all allow high power rifle that's there.
So it seems to me that we have a situation where, you know, we all have rights, right? People's rights end where someone else's rights begin, to a certain extent. And it seems to me that we can accomplish allowing people to have this in the county, which we're required to do, or they can go anywhere. And we can still protect the rights of people who came into an area with an expectation and have been there for 50 years, of an expectation that they're not necessarily going to have a business, which is different from hunting. We all hear hunting going around in our houses, you know, except obviously in the city, on a regular basis. The difference between hunting on an occasional basis and having a business that's banging out shots 24/7
No,
Not 24/7.
sunrise to sunset.
Sunrise to sunset, 12 hours a day, I think is a substantial difference. And to me, it seems logical to me that we, in an agricultural district, the areas between houses are much greater because they're farm districts. They don't have to be, but I think they probably are.
In some instances.
In some instances they're not. I think we need to take a strong look at whether it's necessary to do this in the countryside district.
That was one of the reasons why I had Tom individually reach out to all the municipalities in the partnership, because we wanted to make sure that there were not any concerns about the countryside district individually. And we actually asked them to either respond, and for those that didn't respond, Tom actually called them, and it was presented to each of them. And in each case, they have no comment, so therefore no issues with it being allowed in the countryside district.
Did you get a comment from the municipality in which the?
Yes, they would like it allowed in the countryside district.
Okay,
If I could just make one comment, when we sent our December 4th letter to the Muncie Township Supervisors, they instructed us to reach out to you and comment to the county commissioner. So what we received was not, we're supportive of countryside, but to bring it before the commissioners for consideration. So hence why we're here.
Okay,
That's because that's the process.
right.
Okay. Shannon,
Yes.
you mentioned there's 5 preserves,
I know.
and then somebody mentioned that they were non-compliant.
They're non-conforming. They're not non-compliant, they're non-conforming.
Non-conforming to what? To our ordinance? And are any of those preserves in our 21 municipal
Yes.
partners?
Yes.
So how did they become non-conforming?
They've been around for a very long time prior to the ordinances being in place.
So then I guess my question is, how did that happen? And
Some of them are.
I guess I'm a little confused as to how could that happen? And then this gentleman who wants to put this preserve needs to go through
Commissioner,
these hoops.
what happens is there's many uses that come into play prior to an ordinance being in place. So if you don't have zoning, anything can be put anywhere.
Okay.
Doesn't mean that you don't have to comply with some rules, because they do have to comply with whatever state rules affects their type of use. That is not something that's grandfathered in. But, however, in this instance, as soon as you have an ordinance come into play, because you have a zoning ordinance, you have to allow for all uses in that zoning ordinance, and that's state law. So as soon as you regulate, you have to allow for all uses. Because prior to the ordinance, you can put anything anywhere, basically, as long as you meet code or building or whatever regulations that are required. And many of these, in this instance, this type of use predates even those. In this case, what the Planning Commission and the staff tried to do was to put as much base regulation down as possible, so that there would be something for the zoning hearing board to make the final decision based upon safety and other concerns, and to make sure that in every instance that it's proposed, it will be as safe as it possibly can, or possibly deny that use because it's not in an area that would be appropriate. And that could be in any of those 3 districts, depending upon, we have some resource preservation and resource protection and agriculture areas where there are some small villages and things like that where it may not be appropriate. So
Did we look at any of the other 5 preserves and see how close they are to the buildings?
No,
or
because it wouldn't
the
matter.
residents?
Shannon says no, because it wouldn't matter because they are grandfathered in.
it
No,
would come into
I
play.
understand that.
It would
But this is not. We're
Yeah.
voting on this,
Yeah.
and I heard an argument that it's 600 feet and the bullet can travel 3 miles. And this is by a resident, I'm assuming, here. And so have we ever had instances, do we know of any instances where in these other 5 preserves, we've had an incident of a house being shot?
We are not aware of any of those. We did have some of the, 1 or 2 of the gentlemen who are aware of those preserves, and one of them public hearing, and they have not had any issues.
Commissioner Masser, Mr. Chairman. The solicitor has reminded me that we're not obligated to vote on this today, that the point of the public hearing is to bring these issues to our attention. One of the things I would like to see is the petition signed by the 58 people, if you have it. If,
It was distributed, the county has it. I have one other comment, can I?
Yes.
You know, I don't know when county zoning started, and you're talking about grandfathering. And I'm very well aware of the other hunting preserve when it was put in our area. And we had county zoning. And, you know, I went to county when I heard all this, and I was told, books were open, and I was told that it was not legal in countryside, that a commercial recreational was not permitted in countryside. Well, this preserve was put in I think 2008 and 2009. When did county zoning go into Muncie Township?
92.
92. So this was certainly in force when this was not a grandfathered in preserve. So I keep hearing this grandfathered thing, and that's not particularly so.
Well, it would be grandfathered because currently we don't provide for the use in the ordinance. So because we don't provide for the use in the ordinance, then they can go in to any location.
So you don't have to ask for permits when you do things then? I mean, you just do whatever you want to do?
If it's provided for in the ordinance, then you do have to ask for a permit and
So I
receive
can do
approval.
anything I want to do, and just because it isn't in an ordinance, I can just do it. I don't have to ask permission.
unless it violates state or federal law. You
Right.
couldn't put a landfill in your backyard because there are federal laws about where you can put a landfill.
Well, there was laws in the county zoning that preserve couldn't, recreational hunting could go into county zoning, and countryside is what I was told at the time when I went up to county 6-8 months ago, because it was a paid recreational thing. It's not allowed in countryside. What has changed?
Well, that's the point of the ordinance that we're doing. We're trying to regulate it now so that it can't just be put anywhere. And that's what we're doing, Mr. Keller. This process, and you coming before us giving the input, is to give us some information so we can make a decision.
Yeah, I'm just trying to think, what's different about countryside now than when the ordinance was made to protect the residences and so forth? What has changed now that it's not? You know, that's my question.
So, Tom, without the ordinance, there's been no regulation, there's been no one to regulate what's been going on. With the ordinance, we can regulate it, correct?
Correct.
Or be up to zoning
Yes.
to regulate it.
Just a philosophical answer to that question. Anytime you have a zoning ordinance in place, you have to contemplate all uses. The reality of society, though, is that uses do change. And so that when you draft an ordinance, you can't contemplate all of the uses. I think what's occurring here is there's a use that wasn't contemplated by the ordinance for whatever reason. They have to go back to past draftsmanship if you want to support that. But it's a use that is now becoming more prevalent and one that needs to be considered. And so the process here is to consider where it should be and subject to which factors. I don't know that you're going to get anywhere by, suggesting why wasn't it there before. It wasn't, and that's trying to be corrected. And your input, Mr. Keller, and others is helpful to the process and
It's
appreciated.
just like, okay, if before, if you didn't need a permit and you had county zoning, why does he have to get a permit now? I mean, why?
Well, so here's, what we're doing really is, one could take the position, as an elected official, I'm totally opposed to this at all, just let them put it wherever they want. Right, Shannon? As a commissioner, I could say, you know what, I'm totally opposed to it. Or I can say, okay, I want to regulate it because I don't want them to have the ability to just put it anywhere. And I want to put it in countryside, agriculture, resource protection. Or I could say, you know what, I want to regulate it and I want to put it only in agriculture. And that's what we have to decide. And your input is helpful, as the solicitor said. And we don't have to make a decision today. That's the other thing the solicitors informed us. So you coming today was important in terms of me personally educating me about a part of the problem that I think had eluded me to a certain extent, because the report we got from the Planning Commission was that it was okay. Well, it was okay with the majority, but apparently there were some on the Planning Commission who had some concerns about it in the countryside. And it's made me, as an individual, think more about whether it's appropriate to put it in the countryside.
Are you going to be able to see the petition?
Well, if you get the petition to us, yeah, he will get it to us.
Okay, thank you.
You're welcome. Thank you for coming.
Any other public comment? Mr. Lauer?
I want to say one thing about this. I'm not for it, I'm not against it. I'm just going to comment here. Todd Lauer, Jersey Shore. Speaking to the noise and the distance. Pennsylvania Game Commission, safety zone is only 150 yards, so that, I'm just putting this in there so you guys can figure this out. And we live in Pennsylvania. High-powered rifles everywhere unless you live in Philadelphia or Pittsburgh. If you want to check on their regulations, then you can check shotgun regulations. But I live in the woods, we have deer season, bullets fly, that's just part of hunting. And you know, I mean, I understand that people are afraid of guns, but once you squeeze the trigger, you can't stop the bullet, so I guess it really doesn't matter, and they can travel. That's about all I want to say on that. Thank you.
Mr. Lauer,
Yes, Mr. Mayor.
do you happen to know which district your house is in?
Garth Everett's 84.
No. Would you guys be able to, off the top of your head, Shannon, know
I
where?
don't know.
It's
No
in
idea.
Pine Township?
Porter Township.
Porter Township?
Where at?
We're in Porter Township.
Right outside of Jersey Shore, right on the border, Pine Creek, right on the Clinton County, Lycoming County border.
I think
Well, so
that's-
just,
I think that's countryside.
is it countryside?
I think. I'm not,
Okay.
don't quote me on it.
All right. Well,
I don't
Mr.
think
Lauer, just to
anything.
address your comment, my concern is not in terms of trying to regulate the use of guns. I don't see that as it. What I see here is that people invested with an expectation of what their quality of life would be. And do we have a responsibility to allow it? I believe yes. I don't believe we should ban it in all of Lycoming County. My question is, do we also have a responsibility to honor the expectation that some people have had for 50 years of what the quality of their life would be, and materially change it when it's possible to do it in a different part of the county? In other words, and I don't look at it as this individual owns this piece of land and wants to do it. I look at it as it's permitted in the county in agriculture or resource protection, hypothetically. The individual can go and buy land in agriculture or resource protection and set up the preserve. And do we have a responsibility to, at least, if someone's had an expectation for 50 years that they're going to live with a certain quality? That, I just want you to understand the distinction.
Yeah, I understand. I'm not taking sides here.
No, and you don't
I'm
have
just
to agree
saying,
with me. I just
you know,
want to
But
clarify.
if these people live out anywhere near the woods, I'm sure people have walked around with high-powered rifles hunting deer around their property before. That's the only point I'd like to make. Thank you, commissioners.
You're welcome.
Can I make a point on that?
Yes, Mr. Gar.
Go ahead. I guess I better get
This is the microphone, thank you.
I'm not against hunting, I've hunted my whole life. It's 2 weeks out of the year, and I find that, and we do have neighbors around us told me they do have bullet holes in their property from the regular hunting season. I had one lady told me her horse was shot in the front shoulder during hunting season. So, yes, it does happen, but what we're talking is something year-around, not just now and then. And we got strangers coming in that don't know the lay of the land. Most people that go at hunting season, they're neighbors, they know. You know, this hunting season, I heard 2 shots the whole time, and they weren't right near me. I'm just saying, I'm not against guns, my word. Don't come to my house and look at how many's there. And I've hunted for years. So I'm not against hunting. That's not what this is about at all.
Thank you. Any other public comment? Any commissioners' comment regarding the item? Commissioner Massar, you still with us?
I am.
Okay. Just checking.
On action.
I think the-
I think the only obligation is no further comment. You adjourn the public hearing.
At this time, we're going to adjourn the public hearing. We're going to reconvene the commissioners meeting.
That takes us to 6.0, Myatune, 6.1 Myatune, ITB for equipment tires and tire repair.
Good morning, Maya.
Good morning, Commissioners. This is just a annual bid that we do for RMS, and they will use that on an as-needed basis.
I have a motion to accept the agreement between the County of Lycoming and Dell Development Group.
This was 6.1,
Oh, I'm sorry.
informational item.
I'm sorry, I jumped ahead.
It's okay.
Okay, go ahead. We're on 7.
It's okay.
So are you,
Yes.
you're good then?
Yes.
All right. So then next, we're gonna go to the action item, 7.1 with Shannon Rossman. Agreement with Delta Development Group Incorporated.
Morning, Commissioners. As we talked about on Tuesday, we have our agreement with Delta Development Group that would be our oversight for the year. It's our contract with them that we would turn on and off on an as-needed basis.
Okay, any discussion on this item? If not, I have a motion to accept the agreement between the County of Lycoming and Dell Development Group Incorporated.
I'll move.
I move to approve.
I'll second it.
All in favor, say aye.
Aye.
Aye. So carried, thank you.
7.2 Shannon Rossman Zoning Partnership Fee Resolution 2020-04.
And again, Commissioners, as we discussed on Tuesday, this is the fee that the municipalities, the 21 municipalities who are part of our actual zoning partnership, this is the fee that they pay to us to help manage the ordinance itself. This helps cover the cost of any updates and hearings like today and things like that, or if they propose an amendment to their district. And so we help them through that process. And this just helps to offset some of those costs. And we're proposing it to go from $2 per capita to $2.25 per capita.
So Shannon, let me
Yes.
ask you, when in the zoning municipal partnership, when we have attorneys that are required, are we paying the attorney's fees out of that money?
Anything that is being done to update the ordinance is being paid for out of that money. And it doesn't cover the entire cost, so we are subsidizing that at the county level for some.
Right.
And it doesn't always cover the costs of our staff because we're always reviewing the ordinance to see where we need to make updates. But it helps offset the cost and it provides a continuity of regulations across 21 municipalities. So it makes it kind of a one-stop shop for those persons who are interested in coming in, getting a zoning permit or doing a special exception or whatever on their property.
So then, could one say or argue the fact that county taxpayers are used to subsidize 21 municipalities' issues?
There probably is a little bit of subsidization in there because we are trying to keep the costs at a reasonable level. Most of the municipalities that are involved are very rural and in many cases do not have any kind of professional staff and have difficulty keeping zoning officers in place. So, and that's a lot of the reason why we have so many involved, because it is very difficult to have a person who is knowledgeable and able to regulate a zoning ordinance. So we have that knowledge and capabilities, and our zoning officers do a lot of that work, and it keeps it consistent.
Okay, thank you.
Shannon, you said to update it, also you mean administer the ordinance?
No, this
Not
does
the
not have.
day-to-day administration?
This is not day-to-day administration. Those
Okay.
fees will be coming forward to you in the future. Those fees have not been updated also since.
For the zoning?
For the zoning fees themselves.
Oh, the zoning fees, right,
Yeah,
okay, so
those
the
are
2.25
administration fees.
only goes to costs incurred to.
For the ordinance.
For the ordinance.
Yeah, so you have to update an ordinance, you have to have public hearings, you have to
Right.
hold meetings, you have to put together the language. This is only for the ordinance regulation itself. It does not have anything to do with the fees of actually administering the ordinance. Those actually go towards the person who's applying. That way, we're not getting other municipalities who have their own regulations to subsidize something that a municipality does not have.
But theoretically, part of the 225 covers us having a zoning officer, having Mr. Hubbard. There's not enough there to do that.
A tiny little bit.
Tiny bit,
A
yeah.
tiny
Okay.
little bit. Those
Okay.
are more the zoning fees
Those-
themselves.
Gotcha, okay. So to answer, Commissioner Messere, to answer, I don't know if that helped your question any. The
Yeah,
action,
I'm good.
yeah. Help me understand it, okay.
Any further discussion on the action item? Now I have a motion to accept the resolution 2020 of 04.
I'll move to approve the resolution number 2020-04.
Have a
I'll second that motion.
All in favor, say aye.
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 So carried, thank you.
Thank you, Commissioners.
7.3, Maya Tune, amendment to agreement with Siemens Healthcare Diagnostics Incorporated.
Good morning, Commissioners.
Morning, Maya.
This is a renewal contract that we have for PRC. This is for their system equipment training and testing as needed for urine analysis.
And this is utilized at the prison and PRC.
That's correct. Majority of the clients utilizing it at PRC.
Any further discussion on action item 7.3? Now can I have a motion to accept the amendment to agreement between the County of Lycoming and Siemens Healthcare Diagnostic Incorporated?
I'll move to approve.
I'll second.
All in favor, say aye. Aye.
Aye.
Okay, so carried.
7.4, Maya Tune, text behind inmate mail management services for Lycoming County Prison.
This is a new contract for the prison. What it is, it's a communication system between inmates and the family and their friends using printed mail generated and using computers and handheld devices. Postal service is still an option available to them, but what this will do is provide more of a robust investigative search feature for the prison staff to ensure that nothing illegal is coming through the prison, of course for the safety as well of those individuals too. But it also monitors and manages the inmate communications in real time as well.
Okay, and this is an extra measure for security of staff and inmates, to protect them also. Plus it relieves some of the staff from extra manpower hours sorting through the mail.
Yep.
At the same time protects their safety.
And just to note, there is no cost to the county to participate in this contract. If we decide later on that there's another player in the scene with the services provided, then that could eventually lead to a negotiation on cost where there would be a fee imposed.
So now, yeah, let me just get that clarified.
Yeah.
How long is the contract for?
I believe the contract is for 3 years.
3 years, but it can be terminated upon 60 or 90
90
days
days.
written notice.
Yep.
With or without cause?
Mhm.
Okay.
Yep.
And, yeah, I think it makes logical sense. I mean, it does not cover legal correspondence. As a practical matter, any mail going into the prison is obligated to be searched and reviewed. And the question is, do we have our folks doing it where we have additional security concerns? Or do we have a third party do it who then turns it into a format, a digital format that allows people to still send things at no cost to the taxpayers, and we're not restricting the ability of inmates to still communicate.
Correct.
Right? They can still communicate, they can get photos, they can get things they couldn't get before, because my understanding is that they couldn't get a drawing from their child made with crayon. That would be prohibited. that drawing can now be screened and sent on, so I don't have a problem with this.
I have a motion to accept item 7.4, text behind inmate mail management services for Lycoming County Prison.
I'll move to approve.
I'll second the motion.
All in favor, say aye.
Aye.
So carried. Thank you.
Thank you, Commissioners.
I would move us to 9.0 for commissioner comment.
I have nothing at this time.
I have nothing.
Mayor Vito, Commissioner Massar?
Nope.
Okay. Public comment. Mr. Lauer?
I wish someone else would talk publicly. I'm kind of getting tired of it, but Todd Lauer, Jersey Shore. I guess if I'm the only one to do it, then I'm gonna. Okay. Commissioner Metzger, you weren't involved in this, but you know what's going on. So I'm going to go back to the MCM radio deal for $6.7 million, which is a $700,000 reduction. Commissioners Mirabito and McKernan stated that they estimated that Michael McGrady from the MCM Consultants owed the county a reimbursement of approximately $180 minimum for work they failed to do under their contractual agreement with the taxpayers of Lycoming County. So my question is, how are we on that, Mr. Mirabito? Are we making any headway with our $200,000?
Well, that's a very good question, and I don't know that I have an answer for you today, but I will have an answer, and maybe what I will do is send a formal letter to Mr. McGrady and ask him to reimburse the county $180,000 for the RFP that was not drafted. Okay? And
Sounds good.
I don't know whether we'll have all three signing the letter, but I certainly will send a letter.
Okay. Okay. Have the commissioners decided whether the remaining $20,000 donation for the Mysterious Bridge donation has been located? Has anyone found out whether it was received or not?
That is a good question.
Well, Ms. Toon was gonna check on it the last time, so.
Not me, that was John Lavelle.
Okay.
Yes, Mr. Lavelle of the planning. We'll check into that.
All righty.
Mr. Lavelle this afternoon.
Thank you.
We'll ask the director to follow up.
And one more and I will be done. Okay. How is the sale of the golf course real estate going to affect the rental agreement of $65,526 that Lycoming County Commissioners have for the 24 new golf carts that we purchased last year? Are we still gonna be able to maintain that, or is the landfill gonna end up buying them?
We met with Billy Casper this past week. We have some very positive news that we're going to release next week regarding the golf course. Regarding the property around it, that's still in the appraisal stage and the surveying process in that stage, and we haven't made any decisions going forward towards that at all. That's the property around the golf course, but we'll be releasing a statement next week about the golf course.
All right.
But just so you understand, the sale of that land will not affect the carts, because
True.
that land is not being used actively by the golf course. That is land surrounding it.
Yes.
So it's not being used by the...
Okay, so no one was actually golfing on the land that we're gonna sell?
Exactly.
Yes.
Oh, I didn't know that.
Yeah, well, that's why we're
It took me 3
subdividing.
years for you guys to tell me that.
Well,
Well, I've only
maybe,
been
Oh, yeah,
here
that's-
3 weeks.
okay,
So.
maybe, that's why I was gonna make a smart comment, but...
That's
I-
okay, I make enough of them, go ahead.
No. That's why we have to take that, I was gonna say maybe it took you 3 years to understand it, but okay.
Yeah, well, that's what
Hey!
I heard it from
No, but
everybody,
Mr.
so I knew
Lauer-
what was going on.
That's why we have to take the land and subdivide it from the rest of the land, because it's one big parcel. So that's why we've approved subdividing it, so we can sell it. But
Okay.
it's a good question.
All right.
By the way, all your questions are good questions here.
Well, you know, I don't wanna sound like
No,
a
I
pain
mean,
in
I'm
the
serious.
ass,
You
but I'm
have a
just-
legitimate
I
question. What
like
happened to the
doing this, too. I enjoy
180,000?
this.
What happened to
It's
the
fun.
20? I'm amazed that somebody, that you follow this. I think it's good.
Well, you know, and I can take it, I can dish it out, I'm not afraid to take it. How about it, June, you like dishing it out?
Well, we don't want to
Thank
take,
you.
Thank you,
all
Todd.
right.
Good one, girl.
We don't want to take or dish out.
Maybe I'll start, being a little nicer to some people here.
You're very nice,
Thank
Mr.
you.
Lau.
Okay, any other public comment? If none, at this time, the meeting will be adjourned. Our next scheduled meeting will be on Tuesday, January 28th, and will be held at 10 a.m. right here in this room. Thank you and have a good weekend.
I think that
Thank you, Tony.
Thank you. See ya.